Most people don't realize the massive change in the judicial criminal justice system that occurred during the Eisenhower years. First off, or during the Nixon years, I'm sorry. First off, Nixon had a kitchen cabinet. He had a group he called the plumbers. He had a lot of advisors. Many of the people that worked with Nixon were members of a public relations firm called Hill & Knowlton. And Hill & Knowlton pretty much managed the change of image of the criminal justice system to that of a Napoleonic system. Essential to the Napoleonic system is the fact that power comes from the top down, and you don't need acquiescence of the citizenry like you do in common law. In common law, everybody's assumed to know the law because it consists of a consensus of the citizenry, and it's common to all of the citizenry. So if you've got a majority of the citizenry that agrees you shouldn't go knocking people off or whacking or murdering people, then it's assumed everybody in society agrees with that, and any deviance from there becomes criminal. Not so under Napoleonic Code. It's only criminal if it's specified in the code. So I'll give you an example. When I first left Illinois to come back to Colorado to practice law, I was hired by this law firm, or one of the lawyers in a law firm, to help on an appeal. He had been a district attorney, and there was a suicide that occurred in the mountains, and a person was helping this woman commit a suicide. It was an assisted suicide, essentially. And he wanted to apply the doctrine that somebody in commission of a felony that lives during that is guilty of the same as the person committing the felony. And if the felony happens to be a murder, he's guilty of murder. It's called the felony murder doctrine. So we have this person assisting a suicide by this old lady, and he gets, the district attorney at that time filed a felony murder doctrine case against the suicide assistant. The court ruled that it wasn't in the new criminal code and therefore illegal, or not illegal, and it wasn't a crime. So under common law, it would have been a crime. Under Napoleonic Code, since it wasn't spelled out in the code, it wasn't. And that became a very interesting landmark case, one of the first cases I worked on out of law school. And it was interesting representing the prosecutor on that side. There was a lot of problems when they first tried to implement that in Colorado. I remember they were going to revise it, and one of the things they decided to do was rewrite the criminal code. And the guy in charge of it was an ex-Supreme Court judge. And he was hired by the state of Colorado to rewrite the criminal code. And there were a bunch of us selected to be on a committee to help write the code. And there were defense attorneys and there were prosecutors. Well, we didn't have any work until one day we were all called together, and the ex-Supreme Court justice stands up in front of us and passes out this little pamphlet to everybody saying, "Gentlemen, this is your new criminal code that I've just adopted or just drafted." I looked at it and it was essentially a plagiarism of Illinois' new criminal code. Anyway, he introduced it as his criminal code. And he said, "I want you people to read it and endorse it, and I'll take it in front of the legislature." Well, one of the old-time defense attorneys who had practiced law with this Supreme Court justice got up. His name was C.J. Berardini. And he stands up and he says, well, with all due respect, Mr. Justice, I'm not anybody's rubber stamp, and I'm not going to approve this without review and without discussion. Whereupon he threw the pamphlet down and walked out. And probably 90% of the criminal defense attorneys on the committee followed him out in protest. Well, after a few weeks, a lot of us went back. We worked for, 4 or 5 months debating back and forth about the new criminal code, and finally came up with something. Now, up until then, when the laws of the United States and later the states were enacted, the United States had just declared independence from England. However, they did, as a matter of law, say that the law of the United States shall be the common law of England as of such and such a date. So we adopted common law, we adopted English common law. And that's why until they started codifying, any of us who had trained under common law could go and theoretically try a case in South Africa, India, Canada. I did cases in Canada. Most of the states in the United States, except Louisiana, which is more Napoleonic code, Guam, pretty much all over the world that were common law jurisdictions. This began to change at about the time of the Nixon administration. And it was a philosophical change. And when I go in more into the change, I'll explain this. But if you look at historically how laws developed, you had this Shia law, the Sharia law, it was the law of Muhammad, the prophet, and they had all kinds of adages and regulations adhering to that ideological and theosophical basis. Then you had the law of Rome, and that was a law of conquest. Rome really didn't particularly care what the subjects were doing. They cared mainly about taxes and slaves. So they pretty much left various countries to govern themselves so long as they didn't uprise against them and provided them with taxes, etc. The law was that of the conqueror, so the conqueror set down decrees and the conquered followed them. This was prior to the Christian era, and the laws were based a lot upon the old Roman and Greek law and mythological tenets and traditions, etc. It changed a little bit with Christianity, and the church became united with the legislation, with the government, and Roman law became ecclesiastic law in a lot of ways. So the law of Rome, when the church became the Roman Catholic Church, was incorporated into that. Meanwhile, further north, you had a different set of laws developing along a tribal system, and among the people there that had to conform to consensus. So the consensus meant that when all the people in the tribe agreed that this is right and agreed that this is wrong, that became the law and it became the consensus, and the communities were all together in their decision-making, and therefore everybody was presumed to know the law. Now, the problem with the northern areas, you had Anglos, Saxons, Danes, Jutes, Norwegians, Norsemen, etc. And they changed a little bit, but they did have certain things that they all agreed upon. And a lot of the common law development was also orally developed, traditionally developed with the advent of Christianity going into the Northern Isles, British Isles particularly, and also into France and some of Germany. And it was a little bit different than the ecclesiastic laws of the southern part of Europe, in Italy, Spain, France, Greece, etc. And one of the big difference was the concept of punishment and whom should be punished and what should be punished. Now, with the tradition of the northern tribes, Saxons, Jews, etc., they had this concept of forgiveness. You know, you paid your debt to the tribe. You were being judged by the community whether you were an evil person or a good person that just happened to commit an evil act at one time. So they had various punishments. You put you in the stock. You got egged, etc. There was death penalties, of course, but the act of incarceration wasn't really an acceptable way of dealing with criminal activity back then. The main way of dealing with criminal activity was a thing called ostracism, where you would make them sovereign citizens, you might say. They lived outside the law. The law didn't protect them, because the law protected people as much as anything else. It was a structure and a way of structuring society, a way of structuring behavior, setting up normative behavior, deviant behavior, etc. And these norms coalesced into some sort of series of law, and as the series of law was accepted more and more, people that didn't accept these mores, folkways, etc., were told to leave the community. They were ostracized. It was a very, very, very good way of handling things. I've always thought that rather with white-collar crime, particularly jail isn't really very effective. One effective thing would be taking some ill-gained profits away. The other one would be ostracizing them from the business community, making it illegal or impossible for somebody that cheated or stole or whatever, committed crimes like that, could never be put in a position or never have a position of trust where that could happen again. You put them in jail, they do their time, they count their money, they come back and they do it again. If they were put in a position or branded, that wouldn't happen. And under medieval rules, there was a lot of branding went on. Under Islamic law, the thief gets his hand cut off. Under some laws, they branded thieves. Others, they put them in prison or they incarcerated them. But there were various ways and various methodology depending upon the justice system that was in play. Now, one of the greatest examples of ostracism that I can think was in England, where they shipped bad guys, criminals, put them on prison ships and sent them to Australia. Now, Australia, pretty much outside of the administration, was a society at one time based mostly on criminality or criminals. And somehow these criminals built a society, developed their own rules. The rules of Australia were, again, common law. and they developed, and you had a subset of criminals under there. But the majority of them became regular citizens, forming a regular society, forming a civil society that existed and had rules, regulations, etc. So, this is the main difference. So if you look at the concept, the social constructions of these systems, first off, under the Napoleonic system, it's complicated to determine whether this is a good guy or a bad guy. So the Napoleonic system, since they just care about slaves and taxes, they don't give a shit. If the person commits a crime, you punish him. And that vitiates society. Apparently, it's the same doctrine as the Druids had, that if a child climbs a tree and falls out of the tree caused injury to the child, so you chop down the tree and punish the tree. You punish the cause of the injury. Doesn't matter whether it's an accident or somebody pushed him out of the tree or whatever, you punish the tree. So somebody steals something, you punish him because he stole. It didn't matter why he stole. Now, under common law, one of the big things in common law that you need for something to be a crime is a criminal intent. So the person accused has to intend to harm the other person. You have to intend to inflict harm. Accidents don't count under common law. Accidents count under civil law. So an example of that, for instance, is there was this movie called the Iger Sanction. And it starred Clint Eastwood, and it was a bunch of people climbing the Iger. And during the filming, there was an accident and a few climbers were killed. And the crew and some of the stars were arrested and held pending an inquisition, an investigation. So under Napoleonic Code, under civil law, they arrest, and then while you're under arrest, then they investigate, but they arrest you so you don't get away or escape or whatever. You are arrested until you post a bond, and it's a peace bond where you promise you won't break any more laws and leave the jurisdiction. A lot of times peace bonds get posted, and then the investigation or inquisition can go on sometimes for years. And as long as the bond is honored, nothing really happens to the defendant. Eventually they might find him guilty or not guilty, it doesn't matter, because there are other things go into play. Whereas under common law, you are presumed to be innocent. Under Napoleonic Code, there is no presumption of innocence. Anybody caught in the act or with evidence that they may have done something gets arrested, and he's presumed to be some party in interest and danger until they figure out what exactly his role would be. So in common law, you don't arrest somebody just because he's a suspect. You assume that he's innocent, and you gather evidence to prove that he's guilty. And if you can't gather enough evidence to prove that he's guilty, you don't prosecute. So there's a significant difference on how you were examined to begin with. Also, although ostensibly they're both based on Christian dogma, because the Roman Catholic Church was essentially Roman law or Napoleonic law. Common law in England was a combination of the old Anglo law called the Saxon Spiel and some of the other customs and usages of the northern tribes. A good example I used in some of the classes I taught was the Victor Hugo book, Les Miserables. And in that book, you had a guy who broke into a bakery to steal some food for his starving nieces and nephews. So under common law, doing that would be an excuse. If you're doing something for the benefit of others, it's a mitigation, and you're not necessarily branded a criminal. Under the Napoleonic Code, it didn't matter. He was a robber. They sent him to prison, and once in prison, once branded as a criminal, you're always a criminal. And there was a ex-jailer that haunted him throughout the book because he figured he was a bad guy and he was going to eventually commit a crime because he committed a crime in the past. And once a criminal, always a criminal. And that detective that haunted the hero of the story ended up jumping off a bridge committing suicide because he couldn't reconcile his experience and what he saw over the history of this criminal and what he really believed. So there was all kinds of cognitive dissonance there. Under common law, that wouldn't have happened because you have to have a criminal intent to be a criminal. So let's take the fact that somebody dies. I am teaching, and I've got a baton, and I'm pointing to the chalkboard, and I'm pointing here, and I'm pointing there, and I have a question that I want to ask a student. And I point at the student and I say, James, what is the answer to that question? And the baton slips, and it hits James in the face. I injure James. Am I a criminal? No. Why not? Because I didn't intend to cause injury. It caused injury. It was accidental. There was no intent. Under common law, that's what they call a tort. I intended to have the baton. I intended to put the baton in a forward motion, but I didn't intend for it to slip out of my hand. Now, let's say it slips out of the hand to the point it goes through his cheek and he's bleeding. Okay, if I use such force, it might be foreseeable that that would happen. But again, I didn't intend for it to happen. And there's no crime. There's a tort, there's a battery, an assault and battery both. Now, let's suppose that the baton, instead of hitting the cheek, hits his eye and puts his eye out. That's a real serious injury. Is it criminal? No. It was accidental. It may have been highly negligent, but it's not a crime. Now, this is where a lot of people get confused because they really believe that somebody should be punished if somebody gets hurt. It's unfortunate we've gone that way. But that was one of the basic changes that I've seen in law over the last 40 years or so since the Nixon administration. The change that if somebody's hurt, there ought to be some way of paying, some retribution. It's very unchristian, very old testimonial, an eye for an eye, etc. Intent has nothing to do with it. Well, that's a pretty harsh way to run a society. Now let's take one more example. The baton flies out of my hand, hits the student in the eyeball, and kills him. Is that a crime? Well, under statutory law and under Napoleonic Code, it can be. It can be criminally negligent homicide. And there's statutes saying if conduct is so reckless and it's foreseeable that something like this will happen, and the perpetrator does it anyway, it's highly negligent and he should be punished. And that's where they're trying to fuse Napoleonic Code and common law. It's bad because it abolishes the act of criminal intent. And when you start punishing people for happenstance rather than for being criminal all of a sudden you get a lot of people in jail. All of a sudden you have the highest incarceration rate in the world, and you have a society that expects punishment rather than retribution, rather than restitution or anything else. And you get a very dangerous society that forgets the concept of forgiveness. When I first started practicing law, there was the thing that if somebody did a crime and went to prison, once he did his prison time, he served his debt to society, and he should be returned to society. And I think I mentioned on my trip to Mexico, that was the philosophy behind the Mexican prisons. That's why they had conjugal visitation and kids playing with their fathers on a playground in the prison and things like that we don't have in this country, and we ought to consider having. So there's a big difference between the Napoleonic Code and the common law. And my premise is in my book, March to Martial Law, and martial law is the perfect example of a Napoleonic system. That's what I try to explain in it. Now, I have this one aside before I close. If you look at the countries in the world, and you look at the history, world history, particularly of aggression, warfare, etc., you're going to be hard-pressed to find any dictatorship existing under a common law system, because the power has to come from the people and not from the top down. So, when you have a Napoleonic system or a Roman law system, you can have a Napoleon. You can have a Hitler. You can have a Stalin. Because once in power, they come in with decrees and they change everything, and thou shalt obey is what the rule to the citizens are. And we had a recent example of this. Look at the first time that President Trump took office. He had a slew of what he called executive orders. These weren't passed by Congress. These weren't debated. They were saying, this is the way the cow's going to eat the cabbage. This is the way it's going to be. And he signed all these orders that really affected the structure of our government and the structure of our society and split the public up a lot. This was a prime example of a dictatorship, or the beginning of a dictatorship, and could only occur if we abdicated the sovereign right of the people to determine what is criminal or what is not criminal. And I think that's a real danger, and we ought to be aware of that. And we ought to fight like hell to preserve common law. I'd like your comments on this, please. And email me at dlblewett@gmail.com, or give me a comment under the video here or whatever. I'm really anxious to see how people are reacting to this and whether or not I should continue. Thank you very much. You guys have a good weekend.